discussion is as a result of a process of listening and of assimilating information that has been gathered over the last couple months by a group that represents church and different aspects, different elements and members of civil society. Our panelists this evening include Mr. John E. Charles, whose reputation goes before him, an eminent lawyer and a legal draftsman known throughout the region, and from right here in Dominica, St. Joseph. So we welcome him to be part of our panel. We also have Mr. Anthony Leblanc, who is a governor of the Dominica Business Forum and the president of the Dominica Builders and Contractors Association. My name is Nigel Karam, and I am the Dean of the Roseau Cathedral, and I also represent the Dominica Christian Council. One might ask, why is the church involved in such a discussion on electoral reform, and why does the church take interest? The church has always been concerned with the development of people and the development of this island very specifically. In fact, Pope Francis, in one of his letters and in his writing, says the church is always concerned both with the national and the spiritual development of people, and indeed the whole people in any society. And as part of the task of evangelization, the Pope continues, implies and demands the integral promotion of each human being. And if we talk about Dominica in specifics, we know that the church has been and continues to be a major actor in the social, political, economic, and moral development of the people of this island. Let me give you the understanding with which we wish to continue this evening. It is an understanding of dialogue and discussion. This is the atmosphere that we would like to create. This is the atmosphere that we would like to promote, dialogue and discussion. And that reason and good sense prevails through our dialogue. Now, dialogue comes from a Latin word, two Latin words, dia, logos, and it's really about dia meaning two, logos, reason or word. And therefore it is the meeting of two reasons, two minds, the discussion between two different perspectives. And this is done all in an atmosphere of mutual respect and of openness, where there is the opportunity to learn, to share, to give constructive criticism, and to change if necessary. Dialogue also implies a plumbing of the depths of any particular topic that we are discussing. And I think, and the church desires, that we need fora where people are able to dialogue freely. And so without further ado, the proceedings of tonight will be as such. We will have the two panelists who will speak for about 15 to 20 minutes each, and I invite you to take notes as they speak and to reserve your questions for the question and answer period, which will be after both panelists have spoken. Now, I would like you to know that also we have the group had also invited the chairman or a member of the commission, of the Electoral Commission, to be present and to participate in this panel discussion, but they sent their apologies and indicating that they have not yet reviewed the report that was produced by this group, and so they would not be able to adequately discuss its findings. Senior Counsel Anthony Astafan was also invited to participate, and he is currently out of state and unable to attend. The Attorney General was also invited and is not able to attend. So, without further ado, I'd like to invite Mr. Anthony Leblanc to address us and to give us an overview, first of all, of the results of the Commonwealth report observer's report and also an overview of the report that this group of churches and civil society produced in the process of listening from the different actors in this whole electoral reform. Mr. LeBlanc.
Thank you. Good evening, ladies and gentlemen. I'm happy that you all have made it, and I would like to welcome those who couldn't make it here but are viewing it online. We have 2 streaming sessions now, and I also want to welcome GIS. The Commonwealth report was not very flattering about the press and the media, and I'm happy to see that GIS at least is here tonight. Okay, so as Father Karam said, that I'll be doing an overview of the recommendations by the Observer Group, the Commonwealth Observer Group, and I will also be doing an overview of the group effort and the recommendations. So I will cover why the group was formed, the primary objective, the engagement of key stakeholders, the findings that we had, the electoral and census data, a review of that, a very brief review of the laws and the present bill that is being presented or was being presented, and look at our conclusions, the recommendations that we have, and then I will go back to our summary. The topic that is up for the panel discussion is electoral reform, issuing voter ID cards as an administrative tool in sanitizing voter registration lists. Let me start first by doing a quick review, or rather reading a few areas from the Commonwealth report, the recommendation from the Commonwealth Observer Group. It starts, a number of issues arose in this election, referring to 2014 election, that will require attention for subsequent elections, including the determination and enforcement of campaign finance and integrity legislation, and the qualification to be a voter based on length of residency. Referring to the voters list, it says, the list is, however, widely and publicly discredited, and despite, in the mission's view, being accurate and appropriate in the eyes of existing legislation, the mission does not believe it necessarily reflects the reality or the wishes of the Dominican society. It went on to say, while the credibility and transparency of the electoral process can be claimed, the mission concludes, however, that the election was not necessarily fair due to, 1, lack of balance, and in some cases lack of professionalism of the media, the absence of campaign finance regulations, and the resultant lack of transparency on financing, coupled with exponentially increased expense associated with campaigning, multiple instances of cheating and bribery, including the transportation of electors to the island to vote, and the apparent abuse of the incumbency, including a lack of impartiality in the provision of public services. It went on to say, on the legislative reform, we recommend that the Electoral Commission continue along its current pursuit to electoral legislative reform and urge that it be informed by public and national consultation as well as international best practice. We consider it important that the financial independence of the Electoral Commission be provided for by statute rather than through assurances provided by the Minister of Finance. On the campaign financing, it says, the mission recommends that the Electoral Commission, guided by international best practice, draft appropriate reform for national discussion and debate. This should form the basis for a solution relevant and applicable to Dominica. It is recommended that the elective reform requires each political party to file a return within 28 days of the election, detailing the expenditure and funds spent on the campaign. This should be carried out at a national and constituency level. And it made this additional recommendation. The role and composition of the Integrity Commission should be reviewed to allow for strengthening of auditing and reporting mechanism during an election cycle, and in particular to oversee campaign financing. In terms of the incumbency, the mission recommends greater control on the use of state resources, as well as renewed consideration and better management of when state goods and services are delivered to constituencies. In terms of the voter registration, it says the list currently complies with legislation, but is widely discredited. There appears to be credible public appetite for elections to be more reflective of the wishes of persons resident in the Commonwealth of Dominica. Every effort should be made to hold this debate promptly and act on any outcomes as expeditiously as possible. And on voter ID, in 2014, the mission acknowledged the current progress made under the OECS integration program to issue national ID cards that will serve as voter IDs. We therefore urge that the process is expeditiously completed and identification requirements to cast one's ballot be amended to require an elector to verify their identity using this card. So, ladies and gentlemen, that's a brief summary of the Commonwealth Observer Group recommendations. Let me take you to our report, our interim report, and I'm just going to give you an overview of what we have done, as I've said before. First of all, the group, as is widely known by now, is formed of leaders from the Dominica Christian Council, the Dominica Business Forum, the Dominica Waterfront and Allied Workers Union, the Association of Evangelical, let me say it right, I never say this one right, the Dominica Association of Evangelical Churches, the Dominica Public Service Forum, and we started meeting as early as the 31st of January 2019 with the objective of finding ways for Dominica to achieve the necessary electoral reform before the next general election. When we met, our fundamental goal was to ensure that once the elections are held, that the general populace will feel that it was held fairly, and that whoever won the election won fairly, and that people will continue with their normal life, going to work and being productive. We met with key stakeholders. That includes the Electoral Commission and the Electoral Office. In that we met the Chief Elections Officer, the Chairman of the Electoral Commission, and the Public Relations Officer. We met all the political parties. We identified them and met them, all the political parties. We met the Concerned Citizens Movement. We met the President of Dominica, His Excellency Charles Savre. And of course, we identified the general public as a key stakeholder as well. And this is one of our contacts with the general public. And we intend to do multiple contacts with the general public, because it's important that the public understands its role in electoral reform, and also understands our shared responsibility in maintaining a good environment to live, to work, and do business. Without a peaceful environment, none of that is possible. As a result of the engagement, we found that all the stakeholders agreed that the most essential element of the electoral reform effort before the next general election was to obtain a sanitized list of eligible voters and two, to require a requirement to ensure that every elector is properly identified by means of some voter ID or some ID that will allow the Electoral Commission to ensure that nobody votes more than once at the general election. And also, thirdly, that public education about the citizens' role in electoral process and electoral reform was fostered. We also found that all the stakeholders engaged agreed that the current efforts at sanitizing the electorals list have not borne adequate fruit. All of them agreed. The politicians, the Electoral Commission itself, the President, everybody, CCM, everybody agreed. They also agreed on the current proposal in the bill form to confirm people overseas was not in the best interest. It provided a situation where persons would be disenfranchised, that you couldn't reach everybody. And we will show later that if you don't reach somebody, that person is removed from the list. And also, it is a rather expensive undertaking. All the stakeholders also agreed that other amendments to the body of the laws are going to be necessary to ensure the independence of the Electoral Commission and also to deal with issues like campaign financing and access to state resources by all candidates. The Electoral Commission indicated that it had adequate funding to provide the verification or confirmation, as it calls it, and to issue the voter ID. All the political parties agreed that the accuracy of the electors' registers are of concern. The accuracy is of concern. And that this poor state of the registers potentially compromises the integrity of the elections, opening it up for potentially corrupt practices. That the current body of laws are adequate. All the political parties agreed to that. That the current body of laws are adequate to obtain a sanitized list of eligible electors and issue identification cards to voters. As part of the engagement, we delivered a letter to the Prime Minister asking for his indulgence to allow the process of electoral reform to take place. And from the onset, we identified that two things were necessary and achievable: sanitizing the list and issuing cards. So we delivered that letter to him on the 14th of February 2019. On the 26th of February 2019, we also issued a set of 5 recommendations to the Electoral Commission. This we have later amplified and improved on and resubmitted them in the interim report. Those recommendations were supported by a legal opinion which was dated the 22nd of February 2019 and also issued to the Commission and issued to every political party and to the President and to the concerned citizen movement, and have been widely circulated to members of the bodies that we represent and in the general public. In terms of the data, we had the occasion to review the data of past elections and also to review the data on the census relating to deaths. We found data from 1980 to 2014 with reference to general elections. And in 1980, we found that just over 38,000 persons were registered to vote. And out of these 38,000 persons, just under 40,842 cast their vote. That's about 80%. Fast forwarding to 2014, the list of registered voters was 72,277, and 41,335 persons cast their votes, or 57%. What we saw over those 34 years is that the list of electors increased by 88%, but the number of persons who cast their vote increased by only 34%. So we did some mathematical modeling and taking and assuming that the list needs to be sanitized, that the number of persons who cast the vote is more reflective as a percentage of the electoral list, the real list, sanitized list. And assuming that the number of persons who cast the votes are about 80%, taking in 1980, 80%, we found that the real sanitized list is probably not more than 50 to 55,000 persons. But we were not satisfied with that analysis because into it. So we looked, and for the 20-year period, that's a national census, data for national census, reveals that 554 persons die annually. We made some assumptions here that 85% of the 554 persons are adults. They're over 18 years. And that they have registered to vote and that they're on the electors list. A reasonable assumption. We found that 471 persons would have died annually who would have been on the voters list. Bear in mind that the Electoral Commission and the data shows that generally people register to vote. All right, there's not a question of whether people register to vote. And if people didn't register to vote, the list would not have moved from 38,000 to 72,000. Where are those numbers coming out? It must be people who graduate at 18. Persons progressively become 18 and register to vote. So it is realistic to think that at least 85% of those persons would be 18 years and over and are registered to vote, and that will give us 471 persons. So projecting that 471 persons per year over 34 years, that will give you 16,000 persons who would have died between 1980 and 2014. That would bring down that list of 72,277 closer to 55,000 persons. So our assumption of 55,000 is not far-fetched and is real data. So with that, we looked at what were the critical reforms that was necessary. And our analysis and our discussion agreed that the critical elements that are required is obtaining a sanitized list of eligible voters and issuing them with an identification card, and not withstanding the Electoral Commission's caution in 2014, caution about the legislation not being appropriate enough to issue ID cards. In 2014, it engaged in a process of verification with the intention to issue identification card to reduce the chance that there will be corruption of the voting process. So, we therefore concluded that it is the consensus among the political parties and some of the other stakeholders engaged that the current electoral laws enable the Electoral Commission to dictate the particulars that are required to issue voter ID cards, and therefore prevent or reduce corrupt practices during polls. And the analysis that we conducted suggests that there should not be more than 55,000 persons that would form a sanitized electors list. And given that the Electoral Commission had 300 portable units to do the verification, plus other non-portable units. And given that it was fully equipped to do that verification, that taking only 200 of those units and engaging a little more than the 110 employees, but engaging as much as 200 persons, that the Electoral Commission could verify all of the 55,000 persons in 2 months. And give and take contingencies, teething errors, and breakdown of equipment, we have concluded that the Electoral Commission can verify that the person called John Brown is still eligible to remain on the voter registration list. And therefore, he's eligible to receive an ID. That the person called Oni Leblanc, my father, or Leo Oni Leblanc, as he was better known, would not come for verification because he's dead. And therefore, it is a means of sanitizing the voter registration list. That when the Electoral Commission calls persons in every constituency, every polling district, to verify that they are still eligible to remain on the voters registration list and therefore eligible to issue a voter ID, they are in effect sanitizing the list. And therefore, we made 5 recommendations in our report. 1, that the Electoral Commission reconsiders the use of the regulations under the present law and use the facilities and equipment it possesses to immediately commence the process of verifying that persons registered to vote in each constituency retain their eligibility to remain on the list of registered electors and to be issued an identification card to enable the electoral office to ensure that a person does not vote in the same election more than once. Recommendation number 1. Recommendation number 2. The process of verification and issuing of identification cards locally should commence and be brought to near completion before consideration is given to any effort to undertake a similar exercise overseas. That the available resources that were targeted for overseas should be used within constituencies. Recommendation number 3. The Prime Minister should display moral responsibility by refraining from exercising his constitutional privilege to dissolve Parliament and call the next general election for the next 6 months or during the period when greater effort by the Electoral Commission is realized in the necessary electoral reform unless it becomes constitutionally due. Recommendation number 4. A massive public education process takes place both to expedite the process under recommendation 1 above and to guide and remind the citizens on 1, the elector's role and responsibility in electoral reform and in the electoral process itself, and 2, citizens' shared responsibility in maintaining a good environment to live, work, and do business. And recommendation number 5, that a separate and further effort is to be made to improve on the current electoral laws in order to enhance the democratic process. So ladies and gentlemen, that's my overview, and I will give way to Mr. Charles.
So we'd like to call Mr. Charles to the podium to share with us on his work in producing this report.
Thank you, Mr. Moderator. Good night, participants, persons who are present there. Also, I want to reach out to the persons who are following us on social media, whether it is YouTube or Facebook. I probably should at least give you a background, a brief background. And the brief background is that as business persons in the private sector and as community leaders, whether it's in the church or in the trade union, we were concerned about the climate, a rather unhealthy climate that did not permit civil discourse. I think the moderator highlighted that. So our singular focus was to create an environment where the key stakeholders would find it in the interest of the country to facilitate discourse on a topic that is very complex. Electoral reform is very complex, and I think I want to express my appreciation to Mr. Anthony Leblanc in referring to some of the areas. And therefore, this group were primarily concerned about promoting, defending, and encouraging public confidence in our democracy. We want to prevent that anger and that violence and these lies and untruth, and let us have civil discourse rooted in reality and fact. We wanted to promote the integrity of our election system and process. And that's very, very important. And at the same time, to ensure legitimacy of our democratic institutions by means of mature and constructive discourse on electoral reform. And the way and the manner in which it was going was not facilitating that. So we therefore decided, okay, it's a major task, but we will focus on the most important aspect. What is the most important aspect? We have a credible list of electors. And since there was much talk about voter ID, we decided to look at the voter ID. So our focus were on those provisions of the legislation that would facilitate this objective. How can we ensure that the Commission carries out its function and have a credible list of electors? I just want to go back briefly, and when we talk about the Electoral Commission, why do we say that? I didn't see the Chief Election Officer, and I didn't see the Electoral Office. If we go to Section 38 of the Constitution, we will see exactly what the function of this. It is an institution created by the Constitution that sets out in clear language the functions and the two primary functions: registration of electors and conduct of elections. You register electors for the electing representatives, and you conduct elections of representatives and senators, where we have election for senators. So that is the first part in Section 38.1. But there's a second sentence in Section 38.1 that says that Parliament may confer powers and such other functions on the Commission as they relate to the registration of voters and the conduct of elections. This Section 38, in my view, places a restriction on the power of Parliament to make laws as regard the powers and functions it can ascribe to the Electoral Commission. So it is one of the provision that places a restriction on Parliament, the power of Parliament. The power of Parliament is set out in Section 41 of the Constitution, and there are some words that are very important. Most times we tend to ignore them. Subject to this Constitution. So Parliament has to make laws in accordance with the Constitution. We are not governed by the supremacy of Parliament. We are governed by the supremacy of the Constitution, which is reflected in Section 117 of our laws. Another set of provisions that tend to limit the power of Parliament are the fundamental rights. And I've argued elsewhere that individuals preceded governments. And we'll understand the aspect of fundamental right. So in looking at this act and interpreting this act, we have to be mindful of Section 38. And if we look at Section 38.2, it simply says that, in simple language, that the Chief Election Officer shall assist the Electoral Commission in the discharge of its function. So the Chief Election Officer is basically an agent of the Commission in my view, but the responsibility lies with the Commission. And I must add further, the Commission is not a statutory body. The Commission is a body established by the Constitution. So therefore, when we are reading the powers of the Commission, we have to be guided by decisions of the highest court in terms of how you interpret these provisions. You have to give it a liberal interpretation. So we have to understand what the Commission can do. The only thing the Commission really cannot do is to take an adverse administrative action against a registered voter without having regard to natural justice. And that's where it will come about removing. We have a lot of argument about it, and we quote cases, but what we're saying, the removal of the names of a voter from the registered is an adverse administrative action, and therefore natural justice is very, very important, and I want you to have consideration about that. So when we look at the provisions of the Act, and Parliament has passed two very important acts, and their regulations related to them. We look at the House of Assembly Elections Act and the House of Assembly Elections Regulations. Also, we have the Registration of Electors Act and the Registration of Electors Regulation. We were not too concerned, in terms of getting a clean list, we were not too concerned about the first set. That means the House of Assembly Elections Act and the regulations, because we are looking at certain provisions basically in terms of the Registration of Electors Act. So to achieve our purpose, one, can we get a credible list? We are not saying we have to get a perfect list. It is practically impossible to get a perfect list, but you can have a credible list. And we have provisions that allow us, Section 7, 11, 13, 15, 16, 17, and 28 of the Act, 29, of the Act. And we have the regulations, 12, 15, 16, 17, 27, 32, 33, 34, 35, 36. So you have a range of regulations that we have to look at. Somebody may want to add Section 10 in the terms of who are the officers who are employed at the electoral office that can carry out functions. So we have, in addition to the Chief Registration Officer, that is Section 10, we have the Assistant Registration Officers, those in the district, and we have enumerators. Enumerators, those persons who can go out and knock door to door and find out about you. Our system is very elaborate. We have clear-cut provisions. However, there are certain things that are left to regulations. A lot of things are left to regulations. And when I read the list of regulations, you saw I read quite a lot. So it means it's not too much is placed in the act itself. A lot is left for regulations. That reflects what we call a certain level of flexibility. In draftsman language, it reflects flexibility in the legislation. Flexibility in the sense that you don't have to go to Parliament every time to make a change that will allow you to carry out an administrative function. It is unfortunate we don't understand flexible legislation. Another aspect of flexible legislation is the level of discretion that is given to the administrator of the legislation. So if you read our provisions, particularly the Regulation 37, we see a high level of discretion, and also as you read some of these. So in looking at these provisions, we arrive at the view that it is possible, if the Commission carries out its work and it seeks to inform the populace of their civic responsibility, we can clean the list. It is not an impossible task because there are certain things we have to do. Dead. The Act says that you have the right, particularly in Section 7, you have the right to remain on the list unless and until your name is deleted because you have died. And what are the provisions in the regulation that tend to give the Commission some guidelines as to removing the dead? We might believe there's only one provision, and that provision that says there's a duty on the registrar of births and deaths to give the information. My view and my interpretation of this provision that gives the registrar the power, and that is Regulation 15, I believe, is that it is only a information sharing provision, that you can get information about persons who are dead from a credible source. But it is not the only credible source that you can get information. You can get it from a number of different sources. However, you would need evidence to support that. So if somebody walks in, or if a child, a surviving child, walks in and said, look, I have the death certificate of my father, and I want to present it to you as a registering officer or the chief election officer as evidence of my father's death, I don't think you could tell the person, wait until September where you can raise an objection to deal with that. I don't believe the legislation provides for that. And the reason why I'm saying that is the legislation allows for customs and practices. And if we turn to the Regulation 37, that sets out certain guidelines, what the chief registration officer shall do in terms of inquiry and collecting information that will allow him or her to perform the function, it would be a reasonable reading of that section, Regulation 37. We have to ask ourselves, where can we ground our action in doing certain things? But you have to be mindful that the Commission, again, is not a statutory body. It is a creature of the Constitution. And to carry out its function, you have to read the provision liberally. Is that provision about the registrar of birth placing limitations and restrictions on the Commission in getting credible information that it can remove the name of a person that is dead? So we have this. The provision about objection is very elaborate and very detailed, and it is very complex. It is exceptionally difficult to administer unless we get guidelines from the commission. Because the way it is written, you can be disqualified because of an offense, and a particular election offense. You can also be disqualified because of criminal offenses, and there's a provision that provides for disqualification, particularly if you're an election officer, so you can have disqualification. But the objection is very difficult. In my opinion, I said it calls for a lot of resources, and it is very intensive. It doesn't operate on guess. And let me give you a simple exercise. I do not know if any of you have spent time in district and going through that list. First, you have to get that list, and you have to have the time. And then you have to make it your personal responsibility to always monitoring your behavior and conduct and movement of your friends. It's a very, very difficult exercise. Even the elections officers and do not carry out that function in the village. So therefore, I did not put it in my opinion. When we get comments saying nobody objects, the question is it because they do not know the law, or they do not want to behave properly or carry the civic duty? It's an onerous responsibility, a very difficult responsibility. I'm a social leader in my community, very much involved in sports. I've been a teacher. I know a lot of persons. I was a bus driver. I was very much involved in the Catholic Church as an altar boy. And my family have good connection. And I committed 1 hour to look only at one polling district in my constituency, the polling district where I vote, polling district West. And I went through it, and within that 1 hour, I came up with, right now, the present list, I came up with 25 persons who were either dead or who were away from them, or have departed Dominica for more than 5 years. And then I had to check it. And when I check it again, I realized I had to remove a number of names, about 4 of them. The first one, a very good friend of mine, I had not seen him for 12 years. And then I remembered that this guy is a slight departure from the law. This guy, his wife died about 2-3 years ago. But I wonder if he died also. And because I knew his first cousin, I called his first cousin and said, tell me about your first cousin. And they said, you know, he was there last year, just before Hurricane Maria. He was just there for 2 weeks, but he has returned. So it's a very difficult exercise. Although he was away for more than 10 years, he came here 2 years ago. So people have to be very careful in making the objections, particularly when there is a penal provision. If you make a false statement in terms of an objection, you are likely to be fined $1,500. So you're asking persons to carry out a civic responsibility, yet you have that provision telling them they must not be malicious in what they're doing. Unfortunately, not many of us have spent many time informing each other about our civic responsibility. Because in carrying out that civic responsibility, with the tensions you have in the political air, they may consider that your act is a political act and not a duty that's imposed on you by the Registration of Elections Act. We have not spent much time educating ourselves about our civic duty and responsibility. And therefore, I believe that is one of the areas you will find very little effort being made in terms of objections, although recently we have seen an increase in this activity. In my opinion, we encountered a very difficult category of persons in the way it is treated. They say the person has been absent from Dominica for a period exceeding 5 years. I mentioned briefly about it's a very difficult exercise because the interpretation you can give are all varied. It is varied because we do not have much guidelines as to how you interpret it. One approach is to view it as being a continuous period, although continuous is not in the provision. So it is a very difficult exercise. But we are of the view that this does not prevent the cleaning of the list. If we focus on Dominica, we can get a good idea of the persons who are resident in Dominica, and because of the election rules and the process, on election day, the agent and other persons can have a very good idea of persons who are outside, those who have departed and they're not there. So you can raise the objection because the law clearly tells you that with that objection, and if you find the person is disqualified, the person vote will not count. So we have this aspect. So we were not too troubled about this part. And when we look again, that was highlighted, again, the same provision was highlighted in section 11.3 that says that when the preliminary register is prepared and published, that list shall not include persons who, in the opinion of the chief election officer, appear since the publication of the last register. I talk about flexibility. It is a discretion. It's an opinion that the chief election officer has to make, and he has to make that opinion on information before him. And one of the ways I understand they view it is that the objection should be made when the person is out. It would appear that the person's departure is cured, a citizen's departure is cured if the person returns, even for 2 weeks, 1 day, whatever it is. We did not want to give an opinion again on this because we believe it was not relevant in dealing with persons who are present, because we think the commission can effectively deal with those who are present. And there was another class of persons we do not believe it was problematic. This class of persons, they are citizens of the Commonwealth, who not being citizens of the Commonwealth have departed Dominica, because our provision allows for registration of Commonwealth citizens. So if you're not a citizen of the Commonwealth of Dominica and you depart, automatically that can go out. These provisions I want to highlight, dealing with citizens departing and not being present, in my view, were intended to operate on an elaborate system of data sharing between the Immigration Department and the Commission. That's a view. It wasn't so much one we wanted to talk about, but we can talk about it because this would help, because there's absence of regulations that guide the interpretation of this provision. And the question I'm saying, because of the absence of regulation, it doesn't mean you cannot operate, because where you can operate is in terms of the objection, which I've highlighted is a very difficult part to apply. And most of the objection provisions, you get that in the set of regulations 32 to 36. And we give, yes, thanks. And we give the other provisions that tend to set out what you can do. And when you have to publish the list, it's a specific date in September. And when you do your quarterly list, every 3 months, and you have to go through in recording persons and registering persons who were not registered initially in the preliminary list. The Commission has certain discretion in section 29(2) in giving directions to the Chief Election Officer in preparing the list every year. So our argument is that based on the flexibility of the legislation and also based on the principles for interpreting the Constitution and statutes, particularly you look at the intent and purpose, that it is possible that we can have reasonable interpretation that will allow us to clean the list. The spirit is very important. What is the purpose of the legislation? But more importantly, we highlighted that a duty is placed on the Commission to do its work, notwithstanding the civic responsibility that is placed on the electors and citizens. So this is part of it. We're also saying that in 2013, the Electronic Transaction Act was passed. Information communication technology is an enabler for development, and it should be used effectively not only within the Commission but outside the Commission. Thus the Commission publish guidelines for persons that they can carry out the function. How do I register? How do I make an objection? What form? So the first time I was informed this last year, the objection form was published. How do we get access to the legislation? So in carrying out our functions, we need to have access. Yes, recently the government has put it on the website. But how does the individual who wants to see about election goes on the Commission website and get that information? So there's a duty on the Commission to educate us as to how we can help and perform that. So this is the essence of it. And if this is done within 6 months, we can clean the list. And that is the essence of our legal opinion. I want to thank you.
Thank you very much, Mr. John Eliu Charles, for your presentation. Thank you very much, Mr. Leblanc, for your presentation. And now we will open out the floor to any questions, any comments that you would like to make to the panelists. I just ask you to please stand, indicate who you are, what organization you represent, if you represent an organization or a media house, or yourself, and please indicate who you are directing your questions to. So the floor is open for questions, clarifications, comments. Everybody's happy. Somebody had a question? Yes. Your name, please?
My name is Gillen Richards.
Yes.
I have listened carefully to my learned friend's delivery, which focused on the cleaning of the list. My particular concern is with respect to identification. With respect to identification, Section 19 of the Registration of Electors Act specifically gives the Chief Elections Officer or the Electoral Commission a discretionary power to provide for identification either by iCard or by other means. In 1974, regulations were made with respect to identification and other things. Regulation 15 clearly prescribes that the Chief Elections Officer shall put on identification cards the names and the addresses of electors. But the provision is not limited to that. It is broad enough to include other aspects of identification, like your fingerprints, your photograph, your eye specification, your facial specification, the same thing as photographs. I believe that whereas the Section 19 of the Act gives a discretionary power to create identification cards, Regulation 15 imposes a duty on the the registering office, chief registering officer, which is the chief elections officer, to create those cards. The question that arises is whether the chief elections officer from 1977 had before been performing that duty. I do not agree with any conclusion that suggests that Regulation 15 simply gives an option. It says the chief elections officer shall. Now, one has to consider what is the purpose of putting particulars on an identification card. I am suggesting that it is for presenting it to wherever the elector has to go to prove that he can vote. In the district, in the police station. I further therefore believe that there is an implied duty, since that is the ultimate objective of that provision, on the chief elections officer to issue cards so that people can be properly identified. I will never, with due respect to whatever opinion has been expressed, rest until we pursue the chief elections officer to question whether he has been performing the duty, to question whether he has what the regulation says he should now have on cards. And if he has that on cards, then why has he not issued those cards? I have listened. I believe as far as identification is concerned, we have sufficient legislation in place to ask the chief elections officer to pursue his function, perform those functions under Section 50, or Regulation 15. Now let's suppose that the chief elections officer has not been performing those duties. Who must be blamed? The Electoral Commission, because I believe the Electoral Commission has been vested with a supervisory jurisdiction over the chief elections officer, which I believe is merely an agent of the Electoral Commission. Why have we not been asking questions along that line with respect to identification? I totally agree with my friend with respect to the cleaning of the list. But what is most potently important in this regard is the proper identification, the facial recognition of persons who must be required to vote or who are entitled to vote. And unless we pursue this course, the Electoral Commission will rest on its laurels believing that it has no statutory duty to issue cards. Now, you don't need to take what I just said lightly, or you don't need even to believe it. I urge you to read Regulation 15 and tell me if you don't see a duty there. And if you see a duty to create cards, then there must be necessarily, sir, an implied duty to issue cards. Thank you.
Would any of the panelists like to respond to that?
I cannot add any gloss on what the council have said. However, one of the drawbacks we suffer in this country relates to the process of lawmaking. There's a cost in administering legislation, and if some of you can recall the experience of the integrity in public office legislation, it was passed, it took 6 years, And the argument that was being presented, it's a costly exercise and you have to implement it. The normal practice is that if you're going to develop a policy, the cost implications, we have to do it. You have to spend time saying what is the cost for administering that legislation of the first 5 years, the next 3 years, and so forth. We do not pay much respect for the rule of law, and we do not encourage appropriate discussion. And so that has one drawback in terms of it. It's not an excuse, but it's correct. Regulation 15 mandates that there are 3 things you must have: the signature, the registration number, and the name. You can choose to put other things. In terms of biometric data, that raises other issue, but I just want to tell you, and we all know it, there are 2 departments of government that take facial features. We have the immigration and passport part that takes our picture, biometric data, and we have the licensing department that takes our pictures. We also have a statutory body that takes our pictures in terms of the Dominican Social Security. So the concept of getting an ID card is not so difficult that it requires a rocket scientist to deal with it. So then the law is quite clear. We might go into other discussions if you want to talk about that.
Any other observations or comments? Yes.
Mr. Chairman, with respect, I do not think that our purpose here, I am really a stranger to this forum, but I do not think our purpose here is one that should inject into the discussion, this forum, the issue of cost. We have had sufficient information from government that everything has been put in place with respect to identification. They have acquired the machinery, the technical know-how, although from an agency that I do not have much confidence in based on the history of the agency if one reads the internet. However, that agency can be employed to do exactly what I'm just suggesting, to put all those things on an identification card and get it ready for elections almost immediately, because I believe if the electoral chief elections officer had been performing the duties imposed upon him by regulation 15 from 1974, we would have had cards with the identification requirements specified in the regulation at the electoral office. I believe it is not within our purview as persons who are seeking electoral reform to make excuses for why the government after so many years has not moved with a certain amount of alacrity to achieve the objective of electoral reform. So cost is not our question here. It should be action, because when one reads the recently published Steps to Electoral Reform, which I responded to, I haven't seen it published anywhere, I clearly said that all that has been said in that document was no more than a collusive effort to deny the people of Dominica the rightful entitlement to have free, fair, and transparent election. You cannot be talking about so many thousands of dollars having been spent toward electoral reform, but you cannot put together a simple electoral card. We know that the Electoral Commission published not too long ago that they had engaged the services of SEMLEX, which is mired in corruption in Africa, to put together our identification system. That is the same SEMLEX that has been reported to have been created its own identification cards, its own passports, its headquarters in Belgium, has been raided by the police based on those very allegations. This is the same company we have contracted to do what? It seems we are following things that smell. I put no water in my mouth to say, so I'm not here for diplomacy. I'm here for what is rightfully belonging to the people of Dominica, a free, fair, and transparent election. So the issue of cost cannot be a consideration in this forum that should inhibit the process of electoral reform. Thank you, sir.
We have another question right here. Yes, in front.
Thank you, sir. And my compliments to the two gentlemen for have really done a lot in research and made an excellent presentation this evening. On the question of why we have moved forward with the card, and as the gentleman before me said, and I agree with him, that the question of cost should really not be an issue. In fact, it has been told to us in more than one occasion that they have the equipment and they have the resources to do what has to be done. The question is that there are seemingly some legal matters that pose a problem. And a lot, as we know from law and lawyers, each of them has a different opinion, very often colored on the political side, but that's the real world. The point is, I think, that if we want to move forward, it seems to me this panel has put forward seem to make a fair amount of sense. But unless they can meet with the Electoral Commission, with the powers that be and whatnot, to get some action taken. Because that seems to be what's holding us back. What the honorable gentleman before me didn't, for instance, acknowledge was that a simple card, picture card, as produced by Social Security and the passport people even, and driver's license, does not include the biometric thing. That had become an issue. As I understand it, subject to correction, they were in the process of issuing cards. In fact, some cards were issued. When some bright sparks who wanted to create some problems said, but do you have permission in terms of privacy laws to put all that kind of information on a card? And I gather that therefore it was stymied for a while, but you would hope at some point somebody gave some opinion or said, well, we have to change the law or whatever. Nothing has happened there. So I find it's the moving forward, the action, because as has been suggested, it's not an issue that cannot be resolved, you know, this bloated list. But I don't know, I suspect because one side feels if they can clean the list more, they have a better chance at the polls. Whilst the other side figures, if we keep it open, there's more chance that we can do better. I think that's a fundamental point. But we have to recognize that and deal with those issues. And at some point, maybe have to come to a compromise. But let's try and move forward. And again, I compliment you.
Thank you very much for your comments.
I heard Mr. Bellot suggest that we need the complicated biometric data, or the Electoral Commission needs the complicated biometric data that is more than facial recognition, that deals with your pupils and the distance between them and all of that. This type of information that we are told in modern technology a drone can use to target you. I must remind him that recently in Jamaica, this type of data that was attempted to be gathered by an act of parliament was turned down by the Supreme Court for Jamaica. It is an effort that the Commission seems to be making to get excellence in education at the expense of doing something. Good can get us there, but we want excellence, and therefore we do nothing because we cannot get excellence. And that's a fundamental problem. It is a fundamental problem. Regulation 15 allows the Commission to issue the ID cards. But that's not good enough. And that's what we are saying. If we get the ID cards, issue the ID cards, the process of verifying that people are eligible to remain on the list requires that you'll issue them the ID cards, and in that aspect, you'll be sanitizing the list. And one of our recommendations is that it's an administrative activity where the commission presents or has two lists, one of persons who are verified and therefore can be issued a list with what is required under Regulation 15. You can issue an ID card, with what is required under Regulation 15. And the other list is persons who have not come forward. That include those who are dead. That include those who are non-resident and who do not come forward to be issued an ID card. If those who are non-resident happen to come to vote, then that can be dealt with, because we know that that list of persons who are verified and issue an ID card can go to vote without much more verification. And the commission, the registering officers and persons at the polling districts have less to do. So this talk about excellence supersedes everything and therefore we can do nothing is not acceptable.
Yes, I just want to make a comment. I really have to express my appreciation to council in terms of how we have dealt with the cost. It was very important, and I think it clearly outlined it. I simply indicated that one of our failures in approach to lawmaking, because in the similar vein, I would say that government has at its disposal vast resources available. It might not just be cash in the process of lawmaking. And if I want to, Mr. Bellot, use your name, you raised something that is very disturbing to me in terms of process. Do we have to second guess the factors that inform policy making? Or is there a duty on the government to be forthcoming, a duty of candor, to tell us these are the situations that we have, this is the legal opinion that we have received, these are the factors that are informing our policy, and that is the policy choices that we have made. I do not want to be sitting here and to be guessing why they are not given the card, because somebody raised an issue about the storage of biometric data. It is very uncomfortable even to admit that, because in developing policy we have set procedures. Cabinet asks for a cabinet paper. Normally it's around 4 pages, but we have attached to it research documents and information that will inform us as to some of the issues. We have international documents that talk about protection of data, and the same 2013 in terms of the EGRIP legislation, electronic governance for regional integration. We have a bill dealing with data protection, guiding us with also information. However, we have moved forward, and if we find out we have moved forward and we are integrating, and the question I do not want to second guess, why a national ID card? Is it to travel? I do not want to be guessing that. And why are we sharing data? Is that sharing data related to election? I do not want to second guess that. I should be able to read a document from the government. Most times we call it a discussion paper, setting out these things, particularly when it affects our right. And in my presentation, I mentioned about the fundamental rights. So if biometric data affects our fundamental right, the government should be forthcoming with us as to the information on which is making the decision. So it is very disturbing, and I'm very troubled about that.
Thank you very much. I think we have one question right here.
Good night. The name is Clarence Christian. Right. I am for reform, and I don't think anybody do not want reform. But any reform must commence with the 41,520 persons who voted last election, because they were in Dominica. They have not been out. Those who are out of state have not been out for 5 years. So they are eligible to vote. So if we are going to issue cards, those 41,500, every single one of them must receive a card, because you cannot disenfranchise them because they are eligible to vote. I do not know if anybody took that into consideration, right? And I also want to ask the attorney here. There was a recent case in Canada, which is a Commonwealth country. Did you take this into consideration? Because it would have persuasive effect on Dominica that says the 5-year absentee rule is unconstitutional. That is a major case that deals with voting rights. Secondly, I want to state the registration, the electors list does not deal with residents, because it's not only residents that vote, it deals with citizens who are duly registered. And every case law, all the acts I've been saying, once you are on the voters list, you're a citizen of Dominica, you are registered, you remain on the list until you are dead, you automatically removed, or if you are out of state for continuously for more than 5 years, you can only be removed by an objection. And the law from 34 from 4 explain and provide a regime of how we remove people's name from the list. Based on your suggestion, are we going to ignore the regime which is set out in the regulations to remove people's name from the list? Because there is case law, the Ferdinand Frampton versus Ian Pinard, when one of the judge said the law, the regime is there to be followed, and it must be followed. It's not, it must mean something. So I do not know, but I am saying I am for reform. If we have to start giving people ID cards, all of the 41,520 persons who voted last election, they are eligible to vote, and you have to give them ID cards because they have been in Dominica for at least 5 years or within the 5-year period. Well, so, yeah, some of them may be done.
So we'll give the panel a chance to respond. We'll let the panel respond first, and then, yes.
Thank you, Mr. Christian. I appreciate your eloquence on the matter. I can tell you the right to vote is part of the very fabric of our democracy. I strongly believe in it. And if you probably took time to read our report, you would realize we are simply saying that same thing, that eligible registered persons are and do have the right to remain on the list. And if you were listening to my presentation in terms of the difficulty presented by this category of persons, you would realize I'm very silent in my opinion. Very, very silent, and it is a deliberate action on my part so as not to disenfranchise persons who are there. The purpose for that is why in our opinion, we focus in giving and dealing with the dead persons, because this will give us information. You raise something that is very important in the sense that the commission has the powers to use administrative tools and mechanisms to have an idea of who voted. So on that list that they have, they can tell us exactly how many persons who voted and whether these persons qualify. So that gives added information to our argument that the commission can issue ID card, and from that list it can find out how many persons have died. So the exercise is even easier having regard to the administrative tools they have at their disposal. I want to thank you. I deeply appreciate the information that you have given to us.
Okay, I just want to add two things to that. And for clarity, we are not saying that once you are not verified, you're removed from the list. We are saying it's an administrative tool to have two lists. One of persons who have been verified and can be issued an ID card, and another one of persons who have not been verified. So that makes the commission works much easier. Commissions work much easier.
Yes, no, there's a little part I need to explain to you, and I think we were not clear about it. I need to explain that. Those of us who have been going for passport recently, where they're asking us to produce our birth certificate, realizing that the name, some of us, the name that we have been using is not the name that we ought to be known by. So people can do one of two things: either have a deed poll and say, this is my name, I want to be called, particularly if their father is dead, or have a statutory declaration if their father is alive to insert the name of their father. Because it was not compulsory in our civil registry to have the name of the father unless the father goes and actually be the person who declares that. Again, we have a little problems, and we have not spoken about that, the problem we can have in our civil registry. And those of you who go for passport knows that. The other thing we have, there was an old system where we just say, I have a boy child. So you might have your father's name, your mother's name, but in the civil registry you have no name. We have this kind of problem. And the third problem we have is the spelling. Is your name Susan, S-U-S-A-N, S-U-Z-A-N-N-E. We have serious other problems that will affect the verification. I am not talking about that, but we have not addressed that. So discussion allows us to see some of the challenges. So while your name might be on the register, I have a cousin who is 67 years, and it's only last year she realized her father's name was not on the register. So she was known by this particular name all her life. So you have to go for a course and make an application to the court to have the name. That can take a long process. We did the short process. We just made a deed poll and we just say that is your name you're known by. But her father's name is not there. Her father is dead. So we have to, I do not know if that factor was taken into consideration in the decision making. So I just want to draw that to your attention, Mr. Clarence. So when you're given that, you can have this problem to think. Let Mr. Chairman, let Mr.
Mr. Christian, just 1 minute. We had a response from the audience.
Mr. Chairman, I don't know if it's chairman or Mr. Moderator, whichever. I beg your forgiveness if I'm
No
wrong.
trouble.
There seemed to be a misconception with respect to registration and eligibility to vote. The Constitution establishes a right to vote. And once you're registered, you remain registered. The same Constitution, Mr. Chairman, vests in Parliament the jurisdiction to determine who can vote. So Section 7 of the Registration of Elections Act determines who can vote, or more properly, who cannot vote. Nobody is claiming that that provision is unconstitutional. If you're bankrupt, you can't. You're dead, you can't. You remain out of Dominica between the two elections for 5 years, and you did not come back, you can't. It is obvious. The other point with respect to the 41,000 persons who voted in the last election, Maria took a lot of them. Hence the need, okay, to clear the list to ensure that those dead persons do not vote again. Now, I don't know why that is so difficult for us to at least apprehend, because death is a constancy in Dominica between elections. So if death is a constancy, cleaning up the list must be a constancy, Mr. Chairman. And the Registrar of the High Court is expected to deliver to the Electoral Commission a list of all persons who die within the specific year. I am urging this body to get from the Registrar of the High Court that list if they can. If they can't, then ask the Electoral Commission for the list that the Registrar has submitted. It is a wise thing to do, so that that list can be distributed in every constituency, so that constituents and other interested persons can go through the list, identify the dead within their constituencies, and speak about the dead. I'm suggesting that most profoundly, because I believe that is one of the issues that we have been missing.
Okay.
I believe the issue of the right to vote cannot be denied. But I believe Mr. Christian is fundamentally wrong. His proposition is fundamentally flawed, because he has omitted to consider the dead persons within the 41,000 that he's talking about. With due respect to Mr. Christian, I believe he should return to looking at cases not in Canada, but in CARICOM. And the most recent case out of Guyana has just showed that if you have been out of Guyana for 5 years, you can't vote. If you want to vote and you're out, you must come in. I don't know why Mr. Christian, because Canada is within the Commonwealth, choose Canada, but not our neighbor. Okay, the community that we belong to justify the point that he has made. I believe my point is stronger than his, and I'm urging this forum to adopt my point. It is our law. It's not changed. If Mr. Christian wishes to change it, then he must proceed to the court and ask the court to say that it's unconstitutional. Thank you very much.
Yes. Yes, Mr. Christian, 1 minute to give a rebuttal.
Okay, no, I'm not going to rebut.
And then we have Mr. Dyer, and then
I am going to say
two more
dead
questions.
people do not vote in Dominica and has never voted in Dominica. Let me give you, I wanted to
let us
I wanted
please
to refute,
listen.
because I have the data there of last elections. I want to refute the data, or my friend Mr. LeBlanc gave. Between 1995, and I want you to take notes, because I have 1995, there were 57,632 persons on the voters list. 37,563 persons voted. That is 65% of the electorate. In 2000, there were 60,266 persons on the voters list. That is an increase, new registrants of 2,643 new voters registered. Guess what? 36,244 voted. That is 1,319 less than the persons who voted in 1995, although the increase was 2,643. In 2005, 65,989 persons were on the voters list. 38,927 voted. That is an increase over 2,000 of 2,683. And in 2005, between 2005, 5,623 persons were registered. That is new registration, 5,623. Guess what? The number of the increase in voting was 2,683. Again, in 2009, 66,923 persons were on the voters list. A significant decrease. 36,905 people voted. That was a decrease over the previous election of 2022. So although in 2009, 1,034 persons were registered, the decrease in persons voted was 2,022. And in 2014, there was 72,277 persons on the voters list. 41,520 persons voted. And in that year period, 5,354 new registrations were made. And guess what? The increase was 4,615. If you take the average, which has been very constant, very, very constant, is 38,000 over the period, 38,231 persons voted over the period, and the average persons on the voters list was 65,597. Between 1995 and 2014, you know what is the increase of voting? Just 4,037 increase. That's the increase. That is an average of 1,000 voters every election cycle over the past 4 election cycles. The increase have been just 1,000 voters.
Okay.
Whereas over the 4 years, 14,654 registered. Out of this, just 4,000 increase in voting. So it means therefore another 10,000 did not vote, of those new registrants did not vote, or whatever it is for the increase. So we have been although we need reform, there have never been any fraudulent voting as the data is showing.
Thank you very much, Mr. Christian, for that data. So we will just have the panelists respond to you, and then we will take a few more questions from the audience.
Okay. In an age where decision is made on information, and we're saying, yes, this data may be important. The question we are asking, are they relevant? Relevant in the sense that we are administering a system. So if we have percentages and we're making projection, the commission has to prepare ballot papers, has to ensure that ballot papers do not run out. So the commission need to have accurate information where it can make this kind of decision. It would be a very embarrassing thing to make certain decision. We also have to be mindful of wastage. It doesn't make sense prepare 7,000 ballots and you're going to dump a number of them wastage. So therefore, in efficient management decision, those persons who are involved in management decision have to rely on credible information. So if the source of the information is suspect, we are not saying anybody's doing anything badly, but the information we have collected. Let us assume that, as I've indicated, in St. Joseph West, where I looked at 20 persons, 4 of them I have credible information that they are dead. And others are outside and they have not returned to Dominica. These are my personal friends. I have not made any objection because I don't believe they'll come back to Dominica. One has been out for almost 24 years. The last time, and he's New Jersey, I can tell you that. The last time he was in St. Thomas, where I met him in 92. When I went to New Jersey last year, I looked for him. I couldn't get him. I have access to reach him. The 2 of them in Alaska, and they're personal friends of my family. So these persons are not there. We have not raised objections. We have not removed them. Let us assume that we make the reasonable objection as our civic responsibilities. So the percentage will change. The numbers will change. You will know how many ballots we have. I do not want to put a good friend of mine there in any position. But in September, some individual brought a list to the electoral office and they say, this is what we have done and we have so many persons there. And if there's credible information that these persons are not there, we're not accusing anybody of falsifying, doing anything wrong. We are saying that if we can remove the names of those we have to remove, we will have credible information where proper decisions can be made and do not embarrass us. That is all we are saying. It's not any accusation, and I'm not taking a pacifist position. I'm not afraid. I'm one of the Dominicans who have no fear. I have no fear whatsoever. I have not seen the man or the woman who I'm afraid of or the system that I have encountered. I have confidence in myself because I grew up with love in a home of honesty and justice as a Catholic. So I have no fear. So we are not accusing people about them things here. So let's understand that.
I just want to be brief. I'm still perplexed about Mr. Christian's point. The fact that the data he said that he's reading, table 1 of our primary report gives all of this data. We are very transparent with all the data we have given. We have shown an increase in the registered voters by percentage, not just by numbers, but we have shown the percentage increase as low as 2% between 2004 and 2009 elections, and as much as 17.2% between 1980 and 1985. We have also showed that the persons who turn out to vote in some elections has actually decreased, and in some elections have increased tremendously. The greatest increase we had in voter turnout is 12.1%, and we have had negative voter turnout as low as minus 5.4%. So we have been very transparent. So I don't know where he's getting to. The point is the registered lists have increased from 38,402 in 1980 to 72,277. That's an 88% increase, 88.2. And the number of persons who cast their vote increased from 40,842 in 1980 to only 41,335, 34% increase. Something is wrong.
All right, so we have a question in front. Yes, please.
Thank you.
Yes. Yes, you need to put it a little bit to your mouth. Yes.
Thank you, Mr. Moderator. Let me first congratulate this body for taking on this task. And I think the objective is to make sure that we have free and fair elections in Dominica. The Electoral Commission is charged under the Constitution, and it's a creature of the Constitution, to ensure just this, that we have free and fair elections. The Election Commission is an independent body under the Constitution, subject to no control over anybody. It's their responsibility to ensure that we have free and fair election. And for you to vote in Dominica, you must be 18 years and over. You cannot, if you are 17 years, vote in Dominica. So it is the responsibility of the Election Commission to ensure that everybody eligible to vote at the age of 18 above have a voter ID card. That's a voter ID card is the best way that you can ensure that you have people eligible to vote on the voters list to vote. All the Caribbean islands have voter ID card. Why is it so difficult for us in Dominica? And talking and jumping and talking and up and down to issue voter ID cards to the people eligible to vote. Why is it so difficult? And as I said, the commission is subject to the control of nobody. So the commission must ensure that the people who are voting have their ID card. The Social Security issue cards. Police traffic issue cards. You have a passport. So why can't you not have a card only for voting, which is so important for the governance of our country? And it's the responsibility of the Election Commission to do just this. The Parliament must vote the money they want. They must submit to Parliament the cost. They haven't got to go to any minister of government begging. Another thing I want to talk about is the question of the voters list. And Mr. Charles made mention of a cousin of his who was away for 12 years. I remember 12 years, and he came back 2 years ago. But he was on the list. The law makes provision in a situation like that. He was out of Dominica for 5 years, exceeding 5 years before he returned. If he comes back to Dominica on the list, he has to re-register again for him to vote. If he comes back, if he stays for an exceeding 5 years, his name is supposed to be removed from the list. If his name is still on the list, when he comes back, he has to re-register. That's the way I read it.
Okay.
Then Mr. Liebler gave some figures about some, is it 550,000?
55,000.
55,000. I believe that is more reasonable. That is more reasonable in terms of having the number of people on the voters list. And I think you all should pursue this to ensure that you all get the accurate figure, but not more. You cannot have 70,000 people and have 70,000 people on the voters list. Thank you.
Thank you very much, Mr. Dyer. So, thank you for your comments. We have another question from the floor, and then it's already 9:15. I don't want to stay past 9:30, so we will take about 3 more questions after our brother.
Yeah, good evening. My name is Bernard Allen, and this topic really touches me because up to this morning I had the rare opportunity of having an interaction with the Attorney General, who was on DBS radio. And I think it is the government on this particular issue should be ensuring that they either have public meetings like this and in other forums, rather than having radio programs that where particular people listen to particular radio stations, and it is very difficult to get a phone call in to ask a question, to interact. I listened to a program last week, Thursday, with the Attorney General and Daryl Titt, where I believe they went on for about 2.5, 3 hours. There wasn't, I believe, one phone call. I may be wrong on that, but there were very, very few phone calls, if any at all, on such a delicate and an important issue. Now, my interaction with him this morning, my first question to him was, do you believe that we, the electors in Dominica, have an absolute right to decide who governs us? His answer obviously was yes. So my next question was, why is it that the drive behind this supposed electoral reform, the proposed laws coming through from the government, seem to be more focused on getting a voters list that will be beneficial to the government remaining in power and maintaining the legacy of the Prime Minister, rather than ensuring that we have a list and a facilitation of an electoral office that is tasked with ensuring that we have absolute, free and fair elections. Because if Antigua and others have cleansed the list, we should not have such difficulty with cleansing ours. Okay? Now, I am a perfect example of the law not working as it should. And I'd like to find out whether or not the electoral office has a continued responsibility under the continuous registration system of cleansing that list constantly. 5 days a week you work, is that what you do or is it not? Because the government should be putting into place systems that link information from the immigration department, systems that link information from other departments of government that can indicate whether or not people live here and reside in Dominica. Because the law is based on the residence, whether or not you reside here. Now, I was away from Dominica at one point for full 10 years. I never came to Dominica. My name was never removed. Now, in my view, it should have been removed. My brother has been away for a long time. His name has not been removed. In my view, it should be. That should be part and parcel of the responsibility of the electoral office, which is meant to operate without any outside influence, right? Now, I differ with the opinion of Mr. Dyer in a very simple way. I believe that I now have the right to cast my vote legally, simply because I have returned to Dominica since last year, May, and I have been residing in the polling district where I am registered for more than the required time of 3 months. That, in my view, as somebody who is simply interpreting in a simple way the law, should entitle me to the right to cast my vote legally. I should not have to necessarily go through a re-registration process. Okay? I should simply return for those 3 months. So those who live overseas who wish to vote legally and their names are still on the list, they should return home and do the same. Return home and stay within that constituency for a 3-month period in order for you to automatically requalify. Now, some people say once your name is on the list, you have a right to vote. You have a right to cast the vote. But I believe that you have a responsibility under the law to ensure that you do so within the limitations of the law. And my understanding is the the regulations state, okay, that if you're outside of the country for more than 5 years, you're no longer entitled to cast that vote legally. So your name is still be on the list, but you have a responsibility when you return, whether Tony Astafan or whoever else pays for you to come home to vote. When you come home to vote, you have a responsibility to ensure that you put that X under the law. If you do not do so, there are in fact penalties under the law. Okay? Now, you can get away with it because the persons within the polling station may not realize that you have found yourself foul of the 5-year rule. So they don't challenge you. So your vote slips through. That does not mean that you don't have a responsibility to ensure yourself that you are voting within the law. Okay? And that is something I think we need to make very, very clear. I would like an opinion from the gentleman with legal knowledge as to that, because my view is there's no way that you can say under this present law that simply because your name is on the list, you have the right to vote. You have the right to cast that vote. Nobody can stop you from doing that. They have to give you that ballot paper. However, you must ensure that when you go ahead and cast that vote, you do it within the law. That's my view.
Okay, yes, one of the challenges we have, while our interpretation focused on the Registration of Electors Act, I said we did not spend much time on this because we were not really looking at the right to vote. And in terms of the right to vote, you have to look at the other act, House of Assembly Elections Act. And I think the Electoral Commission has issued instructions and directions about that, I think, last year. And it is section 27(2). And if your permission, I can read it. It says, every person whose name appears upon the official list of electors for any polling district shall be entitled to vote in that polling district, notwithstanding that is not resident in that polling district upon polling day. It is one of the complex provisions that we have, and other complex provision. So the exercise that we have been involved in brought to the fore that there are some provisions in our laws that are somewhat complex, and we need to make it very, very simple so that we can continue to exercise that fundamental political right, that's the right to vote. So in our report, in the amended version or the revised version, that will be the final report. We will highlight some of these and highlight some of the best practices, international best practices to deal with it. And one of the things we have highlighted, and probably not too clearly, although we make a recommendation to the Prime Minister, is that it is not good practice to change the election laws during the year of election. This practice has been shown to be discredited. It raises a certain amount of tension and unease in a representative democracy. And we were quite clear and forceful to the Prime Minister not to go and change the primary legislation. It doesn't. And in fact, as part of our subsequent improvement, we have indicated, and in our first report, it is if, and we really do not believe it is needed, it's only the regulations that may change. And it is not really needed. We just wanted to formalize a system where relatives can notify the commission of the dead relatives. You can actually notify. That's basically it. But you're quite correct. And there are difficult provisions, as we in your presentation and Mr. Dyer's own. Thank you.
Hold on, Mr. Christian, yes. And then two other questions, the last two questions. Thank you.
Thank you, Mr. Moderator. Isaac Baptist, President of the United Workers' Party. Let me express thank you to the civil society groups for having gone so far in trying to unblock the way to free and fair elections in Dominica. And let me also state that the United Workers' Party endorses fully the findings and recommendations of the group thus far. Quick question. It said that you wrote to the Prime Minister asking him not to exercise his privilege under the Constitution to call elections while the process of electoral reform is underway. Has he provided a response to that letter? That's the first one. Secondly, given the fact that I see they have some very sharp and bright legal minds in here, given the fact that the Electoral Commission has recognized the weaknesses in its process right now in terms of the bloated elections list, in terms of the lack of ID cards for voting, and other problems with the process. And given the fact that it is an independent creature of the Constitution, if the Honorable Prime Minister should exercise his privilege under the Constitution to call elections, can a voter or voters who are aggrieved challenge the Electoral Commission from not conducting an elections while they themselves have recognized their weaknesses in the legislation that would cause them not to be able to conduct a free and fair election?
Okay, so I'll allow the panel to make a response to those two questions.
I can only answer the first question since I'm not a bright legal mind. The first question asks whether the Prime Minister has responded. I would say he has exercised his privilege not to respond.
There appear to be varied position in terms of, in terms of respond, and it's not to be too legal, do you get a direct response or do you get an indirect response? Can you infer that you have received a positive response from him? And there are some of us who have been favorable towards the Prime Minister in that we think indirectly he has responded. As to what factors moved him in giving that response indirectly, we do not know. But we look at signals, we look at things, and we seek to interpret it. It may not be our request, it may be other factors, that get him to hold back. But we have been having holding back, and we have been seeing letters and invitations for discussions that tend to indicate that. So I would want to give the benefit of the doubt to the Honorable Prime Minister. Yes. Well, Mr. Baptist raised a question, a legal question, as to, yes, whether or not you can take action against, and I think that's a legal question. We can turn to chapter 7 of the Constitution, particularly in section 103, that talks about the judicial provision, because we have supremacy of the Constitution, and the Supreme Court is the guardian of the Constitution, the guardian of our right. So if you have an executive authority is doing something that a person feels aggrieved, the person can move the court if they have sufficient standing. It's a question of getting the basis, and those persons who are advocate and practice would guide you, but we do have provisions for that.
Thank you very much. It's 2 minutes to 9:30, and I promised 2 other questions, only 2, so we'll take the last 2 questions from this side of the room, and that will be, I'm so sorry, our time is up.
Okay, good evening. My name is Cleville Mills. I'm here really as the president of the Dominica Consumer Protection Association. I did not want to make a comment. I wanted to ask a question, but I think I should make a comment on the answer that we got on the question of the right to vote, because I just thought I was hoping that it would be more forceful, in the sense that we had case laws in Dominica where persons were challenged for voting because they voted, and the claim was that they were out of Dominica for more than 5 years. And the case law was very clear in my mind that even when the other argument came saying that it was illegal to vote because they were out of state for more than 5 years, the court made it clear that the fact that the name is on the list, they had a right to vote. And I think we must adopt that as the last standing case that we have in Dominica, and that's the law as far as I'm concerned. Anyway, the question I would like to ask, because I think the focus of this group is ready to try to make recommendations so that we can solve the matter of electoral reform, or how should we proceed for the next coming general election. In your recommendation, that is on page 10, recommendation 251, where you made reference to talking about ID cards in part 1, but in part 2, you said that the process of verification and issuing the identification card locally should commence and be brought to near completion before consideration is given to any effort to undertake a similar exercise overseas. The available and allocated funds and equipment for the overseas process should be used to expedite the process in the constituencies. What do you do about the persons who are overseas? Because based on number 1, you intend to give identification cards to persons locally. What is your recommendation as to how to proceed with the persons overseas? I didn't see that in the recommendation. I need a clarification from you on that.
Okay.
All right, a very beautiful question. We have to realize that our system of voting is in-person voting. You must come to Dominica to vote. So since we refer to section 27 that you have the right to vote, we have effective, efficient system that can clearly do this. In addition, there are provisions. The question is, we are not saying it is mandatory. We do recognize that you have a number of things, and we do recognize the law as is. While we have regulations saying you must give the person the voter card, we do have that provision that you can use any other means of identification. So the commission can issue, and that's why I said about the flexibility. If you have an identification card and you can actually identify the person, you can ask that person to provide that identity card. The flexibility of the legislation allows you to do that by giving the clear cut. Not only are you going to do that, you will have your administrative tool that will allow you to know who are the persons who are not really in Dominica. We have to use administrative tools to allow us to function effectively. I know in certain countries where their citizens do not reside in the country, their passport is marked NR, non-resident. They use administrative tools to ensure that they can control any kind of strange things. We have to be positive. The important thing, as I said, is that the commission must not take any adverse administrative action against you by removing your name and preventing you from voting. And section 27 is very clear as to your right to vote. I hope I clarified that part. I cannot make it more forceful than that.
And the last question?
I thought I had a question until Mr. Speaker had me more confused. I listen to the debate all the time and understand, well, you can vote once you register to vote. But if you're out of the country for over 5 years, although your name is there, but you are disqualified to vote. He's saying now somebody that happened and they went to court, and the court is saying that the post is okay. I just get more confused. Is the law, is the Constitution guiding us, or as we go we make up things? Because I would think is through the Constitution we understand things. So this was my question. But right now, I'm being honest with you, I confuse.
Let me see if I can, as a non-legal person, answer that question for you. Once your name is on the voters list and you go to the constituency in which you were registered and the polling district, you can cast your vote. Once your name is there, regardless of whether you have exceeded the legal limit for being outside. Once your name is on the list, you can cast your vote. Now, that may be legal or illegal, but you can cast your vote unless an objection is made. Is that correct?
Yes, and it was just removed.
So, is that...
If I may ask.
No, that's the last one. So you are correct. You are correct in the sense that we have engaged in an exercise where we are encouraging persons to read the law. We also have an administrator of the law, that is the commission, and the commission had that responsibility to give us directions unless the court turns around and make an interpretation of it. We are realizing that we do have some complex provisions that appear to be inconsistent. So, and that is why we are saying the process of electoral reform is not a very, very simple process. So it would call for a review of the legislation. It will call for the best minds coming together, which we have to recognize that we have political parties in Dominica and they all play a role. We do have to recognize that there are civil society organizations that play a role, the business community, the labor union, the bar association, the church organization, because we're a community of people and we have to love each other. We all speak that language. So how can we really create that love and be patriotic? And then I say, I am Dominican. You know, if we are going to use that language, our constitution utilizes the idea of consultation. It guides us. And fortunately, the Caribbean Court of Justice, which is our highest court, has given a definition of what consultation entails. Before you begin to think of the proposal, you have to take into consideration persons who can make an input. And you have to give everybody the opportunity to make that input. And when they make the input, you mustn't be rude and insulting and say that they're not contributing. You have to be gracious and say, I will take into consideration the input that you have made, because I want to give meaningful consideration to in terms of the input that you have made. We're not going to insult anybody, and that is what this process is involved. Thanks a lot. We see our pastor wants to pray for us, so let's call him.
Just as a closing comment, I just want to say this non-residency issue has come up, and if you read our primary report, and it will be in the final report still, the recommendations that we put forward to the Electoral Commission include one that deals with that. Read it, it's recommendation number 4. I want to thank everybody for coming, and I want to beg your support in the process that we are continuing. Thank you.
I want to thank you also. It was very nice. I wish you pleasant journey home, and thanks again, and you and your family.
So thank you very much. We've come to an end of our presentation tonight on our panel discussion. It was very enlightening, and I hope that we can have more of these. So good night, everybody. God bless you. Have a safe journey home.
Yes.
Which one you want now? This one? Oh, it have a thing. Okay, Father. It is you must make DBS by you.